This is just kind of a couple of follow-on points on what Joe was saying. I mean, who knows what the true sort of lasting legal implications of the case will be. But for the time being, and these are sort of what we identified as the major ones. I mean, first, the AUMF was a central, was sort of a statute of central dispute in our case. But as Joe mentioned, I mean, the AUMF has really been, a significant part of this administration's legal architecture in the conduct of the war on terror. And by its own terms, we submitted to the court and would continue to submit. The authorization for the use of military force is just that. It allowed the president to call into service the U.S. military for the purposes of invading Afghanistan and dismantling the Taliban government that was there. They've done that. But the AUMF has been consistently cited as the legal basis to take any number of actions of otherwise questionable legal authority and bootstrapped by virtue of the AUMF. Alberto Gonzalez went before Congress and he justified the NSA explicitly on the basis of the AUMF. And what the court said in Hamdan, we believe, is that it doesn't say any more than its words, which are, authorizing military force. The second, probably, more significant thing to come out of the opinion is, as Joe mentioned, is the application of the Geneva Conventions, in particular Article 3. And, the reaction we saw was immediate. And in fact, that Department of Defense memo that Joe referenced actually it applied not only to Guantanamo, but it applied internationally. So it is a recognition that even in places like Abu Ghraib, presumably in other areas where military forces are employed, that Article 3 governs the conduct there. The one potential thing that this raises is, which is of concern to Congress, is to the extent that we persist, that this administration persists in certain of these tactics that have been reported in the press, are the people who authorize those tactics, Rumsfeld, his affiliates, by the strict terms of the Geneva Conventions, they're war criminals. I mean, that is what Article 3 says. So this raises the specter of whether or not our continued conduct, unless it's changed, places some of the highest ranking members of the U.S. government in a position where they could be potentially tried as war criminals, or at least accused as war criminals in the eyes of the international community. And finally, the last thing is that military commissions now, to the extent they're going to happen in the future, must be authorized by Congress. And this is going on right now. Very, very shortly after the opinion was issued, there were hearings before the Senate Judiciary Committee, hearings before the Senate Armed Services Committee, and the focus of these hearings was, how do we change, or do we change, the Uniform Code of Military Justice in order to allow these commissions to go forward? And there are kind of two schools of thought here. I mean, one is the one that was advanced by the same government lawyers who litigated this case, and they came before Congress after it was over and said, all the court has asked you to do is pass a congressional resolution enacting, as a matter of statutory law, the military order that we promulgated in 2001. Essentially rubber stamp what we've been doing, and congressional approval is all that the court is concerned with. There's another school of thought that says, well, no. These deficiencies, these procedural deficiencies, in addition to violating Article 3, they violate some of the most basic fundamental tenets of justice we know. And to the extent what you start to do is tinker with the UCMJ, so it's a two-track system. You have one track that has a set of rules apply to our service members, and one track that has have a set of rules that apply to people, not who necessarily are our enemies, but people who we suspect are our enemies. Those rules will apply to these set of people. And bear in mind, the testimony before the Congress is quite plain. And Senator Hatch says it. These rules are changed so we can get convictions. We need to get convictions. And you know, we've been abusing the bully pulpit up here a little bit, but this is like the world peace section. You know, we submit that this is a very dangerous and sad precedent. The idea that, you know, we need to establish different procedures solely for the purpose of getting convictions. I mean, this is, in my view, totally antithetical to the notion of U.S. justice. And you know, this is not done. I mean, this is something that's pending before the Congress. It's Republicans and Democrats have suggested that this is going to be you know, an issue during the election cycle. So you know, I would encourage you, you know, if you see something called the Commission Ratifications Act of 2006, think long and hard whether or not you support measures that set up this two-track system, because you know, it is a significant break from American justice.